I've seen people give closings where they start from square one and they talk about what the first witness said. They summarize that testimony, and they'll talk about the second witness's testimony. They'll go all through it. The jurors have been there. The jurors have seen it. I don't think that's the way to go. Do what's comfortable for you. It's called closing argument. If you can give a closing off the top of your head, if you can do it without notes, then do it. Maybe you'll miss a little bit of something. Like I said before, their minds are probably made up anyway. What I have done, and this is, for me, and it's usually not typed up, but I've typed it up here. I'll handwrite it usually because there are adjustments I'll make at the end. But when I have to refer to notes, and I've been doing that here also, in my opinion, if you have more than 1 or 2 words on a line, it's just not going to sink in when you're up there talking. You're going to spend too much time reading it. You don't want to have your eyes on your notes. So 1 or 2 words at the most. If you have every line, you've got a problem also, in my opinion. Because you're going to lose your place. You don't want to look down and be lost. So, this is an example of typing it up. And you probably, let me see if I can do this a little bit. And first thing, I just don't want to forget, I want to thank them. I always thank the jurors. Thank you for sitting here and listening to this case. I appreciate it. My client appreciates it. I'm sure the defense appreciates it also. Shame on them if they haven't said it themselves. Usually they do, but I want to thank them also. BOP, anybody have an idea? Burden of proof. You've got to meet a burden of proof. Talk about this burden of proof. The court will instruct you that the burden of proof in this case is ours, which we accept gladly. We have to prove more likely than not. We don't have to prove 100%. We have to prove beyond a reasonable doubt. We have to prove more likely than not. I will suggest to you why we have proven our case. And then you go through the elements. We have to prove that someone was negligent. Negligent because I may have 5 or 6 pages of this, but I'm not going to get lost when I'm looking here. And it's no big deal if I turn the page and get to the next page and it brings me back to where I want to be. Again, I usually handwrite it because it's at the end, and I'll refine it. And it's just a guide, but it's basically to make sure you don't miss anything. At least that's how I operate. So big letters, like you saw, only a couple of words, and space between them. And you'll have your roadmap, you'll have your guide, you'll make your arguments. As far as responding to defense's argument, I save that for the end, just before my little 2 or 3 minute pitch as to why the case should be decided in our favor. I'm not going to lead off responding to the defense counsel. You can't get thrown off your game. You've got a game plan. In the way I look at a trial, you're like a freight train. You can go slow, but you're on a track. You're a heavy metal machine going forward. If you've got the fuel and you've got the track, you're going to go to where you need to go. And they can shoot arrows at you. They can do their best to stop you. You just know what you need to go forward. So you've got your game plan. And in closing, let them know what your game plan is. You have to show confidence throughout the entire trial. And that's going to show in your closing argument, because you're a believer, of course, and you've got your act together. You've got what you need to prove your case. You can, to an extent, respond to what they had to say if something's major, but it's basically poo-poo. You're going to win your case because of what you've got, and hopefully, and I think it does work most times, the jury won't be focusing on their points once you start to go. Once you start to give them your case. You'll see them nodding sometimes. That's a beautiful thing.